Good afternoon. My name is T.Putnam, and this is my legal brief presentation of Naruto versus Slater for course ATE 3515, Legal and Ethical Issues in Veterinary Technology at St. Petersburg College. This case docket number is 16-15469. It was seen in the United States Court of Appeals, Ninth Circuit. The judges seeing this case were Carlos T.B. and N. Randy Smith, as well as District Judge Eduardo C. Robredo. There is a concurrence in part by Judge N. R. Smith, and this decision was filed April 23, 2018. This case was an appeal from the U.S. District Court in the Northern District of California, and it was presided over by Judge William Horsley Orrick. The parties to this case are the plaintiff appellant, Naruto, a crested macaque, by and through his next friends, People for the Ethical Treatment of Animals, and Dr. Antje Engelhardt. The defendants' appellees were David John Slater, Blurb Incorporated, and Wildlife Personalities, Ltd. The photo on the right of this slide is one of the subjects of this case. It is one of the monkey selfies that was taken by Naruto in 2011. David Slater is a wildlife photographer who spent time in Indonesia photographing the endangered crested macaques that live there. During his time in 2011, one of the macaques, a 7-year-old male known as Naruto, took pictures of himself by pressing the shutter button on Slater's camera, which was set up on a tripod. Slater and Wildlife LLC later published the photos in a book created through the website Blurb in 2014. They were claiming ownership of the photos known as the monkey selfies, while also clearly stating that Naruto was the one to physically click the shutter button, as you can see in this photo on the right. In 2015, People for the Ethical Treatment of Animals, otherwise known as PETA, and Dr. Engelhardt sued wildlife photographer David Slater on behalf of Naruto, acting as his next friend, for copyright infringement in the U.S. District Court in the Northern District of California. In the lower court case, the defendants, Slater, Wildlife, and Blurb, motioned to dismiss the case because they felt the facts presented by the plaintiff did not establish legal standing under Article 3 of the Constitution or statutory standing under the Copyright Act. The district court granted the motion to dismiss due to lack of statutory standing under the Copyright Act because Naruto is not a human and therefore cannot claim copyright of the photos. PETA and Dr. Engelhardt promptly filed for an appeal on Naruto's behalf, but then in 2017, Dr. Engelhardt removed himself from the case, leaving PETA to fulfill the duties of Naruto's next friend. For some background information and context to the discussions in this case, standing under Article 3 requires the plaintiff must have suffered an injury in fact, an invasion of a legally protected interest, which is A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. There must be a causal connection between the injury and the conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant and not the results of the independent action of some third party, which is not before the court. And it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. When considering precedent, the judges considered a case from 2004. This was Cetaceans Community versus Bush. In the Ninth Circuit Court of Appeals, determined cetaceans and other non-human animals did not have the standing to sue on their own behalf, even if they can otherwise argue Article 3 standing. In this case, the statutes they claimed harm under did not have wording explicitly allowing animals the private right of action to sue. When considering if there was statutory standing, the judges referenced the Compendium of U.S. Copyright Office Practices, which state the U.S. Copyright Office will register an original work of authorship provided that the work was created by a human being, which is very specific wording and essentially says that Naruto has no standing to claim copyright of the monkey selfies, which then negates his Article 3 standing. In addition to these considerations, the court also discussed whether they even had jurisdiction to hear this case, as it was not clear if next friend standing applied to animals. When considering the validity of next friend status, the courts considered the federal rules of civic procedure, specifically Rule 17C, which states, without a representative, a minor or an incompetent person who does not have a duly appointed representative may sue by a next friend or by a guardian ad litem. The court must appoint a guardian ad litem or issue another appropriate order to protect a minor or incompetent person who is unrepresented in an action. Another definition found in Cornell Law School website, the next friend is an individual who appears in court in place of another who is not competent to do so, usually because they are a minor or are deemed incompetent. Often, the role is filled by a parent or other relative. It can be any legally competent person whose interests do not run counter to those of the person on whose behalf they are acting. These are both very specific when discussing persons who can be represented by next friends. In an interesting twist of the story, shortly after the oral arguments in this appeal, the plaintiff's appellant and the defendant's appellees motioned to dismiss the case due to an out-of-court settlement having been reached between PETA and Slater Wildlife and Blurb. The court did not grant this motion to dismiss and continued to consider the case. They did not feel PETA met the requirements of next friend, as there was no evidence of a significant relationship between them and Naruto, and according to the Federal Rules on Civic Processes, 17C, Naruto is not considered a person for that to apply. The complainant claims that Naruto did suffer concrete and particularized economic harms as a result of the infringing conduct by the appellees, harms that can be redressed by a judgment declaring Naruto as the author and owner of the monkey selfies. Therefore, they felt it included facts sufficient to establish his Article 3 standing. The final court's ruling was based on the previous Supreme Court ruling in Cetacean versus Bush that cetaceans and other non-human animals did not have Article 3 standing to sue, as well as the wording in the Copyright Act that any non-human animal is unable to claim copyright or to sue under the Copyright Act. The judge affirmed the lower court's decision and awarded attorney fees to the defendants' appellees for both the appeal and the district court fees. Circuit Judge N.R. Smith did submit a concur in part. Judge Smith felt that there was no jurisdiction for this case, as next friend status was not met. Therefore, the case shouldn't have gone any further to determine ability to sue for copyright infringement. There was no precedent for animal next friend standing, and he said that these requirements keep people from taking advantage or using cases for their own personal gain. Allowing next friend standing on behalf of animals allows lawyers, as in the case of cetacean, and various interest groups, as here with PETA, to bring suit on behalf of those animals or objects with no means or manner to ensure the animal's interests are truly being expressed or advanced. Such a change would fundamentally alter the litigation landscape. In my personal analysis of this case, I do agree with Smith's opinion on the next friend status in relation to PETA in this case. While I do feel animals have basic rights, allowing them to be represented by others in court, like in this case, will become far too easy to pursue one's own personal interests and agendas instead of those that we assume of the animals. How can a human represent the wants of an animal in the same way as another human, which is something we deeply understand? And while Dr. Engelhardt did have history with Naruto and his community, PETA had shown no proof of a similar relationship. Another interesting point is that PETA settled out of court for 25% of future gross revenue from the monkey selfies to go to a charitable organization that protects Naruto, his community, and their habitat. That was, I feel, wonderful. However, Naruto was not a party to this settlement, which further supports this case that it was more in the interest of PETA's agenda and not necessarily Naruto's. The court likely noticed this as well, as they declined to dismiss the case and issued a decision to uphold the district court's ruling. I feel the courts made the right decision in this case. I don't believe that Naruto was harmed in any way from the release of his selfies, and if anything, they may have brought attention to his kind and their endangerment. Thank you for tuning in to my legal brief today.